Sotomayor.
Mr. Clement, we now have a whole body of law developing on the fact that we're not going to give relief to more than one plaintiff at a time, so that the relief should be tailored to the needs of the plaintiff at issue. Assume that you have a district, and there are some like this, maybe not your clients, but that goes to the failure of pleading in this case, that there are some districts where the Republican registered parties are 98%. The Democrats are 2%. Your rule would say that that candidate who has not just an insubstantial, but a statistically almost impossible chance of losing, that that candidate can come in and seek a change of that rule. Correct? That's your position.
That's correct. And
right.
I mean, and I think—
Doesn't the absurdity of that? Generally, we have said that suits should be brought by people for whom the harm is concrete in some meaningful way. Losing, let's say, by 1%, more or less, can't be meaningful on any scale. So, as Justice Alito said, there are a lot more things you could have said. You could have even said, instead of saying, I risk injury if untimely and illegal ballots cause me to lose my election, you didn't even say, I risk substantial injury, which is our standard, substantial harm. So you didn't even track our legal language. You didn't put in any facts, as Justice Alito pointed out, about what the turnout is, what your district is like, nothing from which any plausible argument could be drawn. I'm also not sure what the battle of the experts is about. This is on pleadings. We have to give your expert, absent some facial deficiency, take the allegations in your favor. So I'm not sure where this battle of the experts is going to come in.
So I'll take the last part first. The battle of the expert comes at summary judgment. Just because we have sufficient allegations doesn't mean we're done. And all of the things that you talked about—
But this was dismissed on a motion to dismiss, no?
This case is, but if we win because we allege all those details about Republicans and Democrats and voting patterns, that doesn't go away in the case. That's still there at the summary judgment stage, and that's where the battle of the experts are. But as to the 2% voter, I'm going to stand with the 2% candidate, and I stand in lock shoulder with the Socialist Workers Party and however many percentage votes John Anderson got, and they were able to—
Bedfellows you're taking.
But I'm delighted to have those bedfellows, because that's the way we think about elections in this country. We don't think, just give me the bottom line result, give me the binary result, winner or loser.
Mr. Clement, that our case law and our standing law requires some form of substantial harm that can be articulated and shown. And what you're talking about is a desire to implement the law with a generalized grievance, because it doesn't really particularly harm you.
So for the Socialist Worker Parties, the difference between 2% and 2.5% might be not the difference between getting some, like on the ballot the next time or federal. It might be the difference between getting taken seriously and in the next election getting to 3% or 5%. I mean, eventually we got rid of the Whig Party. It takes a long time, but those small differences do make a difference. And then the second thing I would say is, just as a general matter, this is not a generalized grievance. This is almost the opposite. Like when you have voters here withstanding, like in a case like Lance, you worry about generalized grievance because everybody's a voter just like everybody's a taxpayer. But when you're talking about whether candidates have standing, like you've already limited the universe to like a handful of people. And so just like you limit the universe, there aren't that many broker-dealers in the world. So you're not going to flood the courthouse with those suits, and you've already limited this to people that have a much more particularized interest in the issues.
Justice Kagan.
So I'm curious, Mr. Clement,